Iowa's Constitution, written and adopted by our founders in 1857, is our state's most important document. It establishes three independent branches of government: the legislative, the executive, and the judicial, and prescribes the duties and responsibilities for each branch to govern this state for the protection, security, and benefit of all Iowans. Our three branches of government have worked together for over the last 150 years to give us our rich history that we can now claim today and the promise for a better tomorrow. The Iowa Constitution also defines individual rights and liberties of Iowans, just as our Constitution of the United States establishes our fundamental rights for all Americans. One of the important responsibilities of the judicial branch is to use both constitutions and the laws passed by the Iowa legislature and signed by the governor to resolve disputes between Iowans. The United States Constitution is the supreme law of the land, but a state, through its own constitution, may provide citizens with greater protection than what is in the United States Constitution. When Iowans ask the Iowa Supreme Court to resolve a dispute, our decision is based strictly on the facts presented to the court and on the applicable law as reflected in our Constitution and statutes. When disagreements occur about the meaning of a law or its application to a case, we refer to prior judicial decisions known as legal precedent. We also research the intent of the law when new facts and our growing understanding challenge our precedent. In a typical year, of the hundreds of cases we consider, 24 or more may involve constitutional questions. The questions can be about free speech, due process, equal protection, eminent domain, home rule, illegal search and seizure, the line item veto, and the free exercise of religion, to name a few. When a case involves a constitutional question, parties will often argue both state and federal constitutional rights were violated. In a single case, they may cite 10 or more Iowa Supreme Court decisions and several more United States Supreme Court or federal appellate court decisions. These cases guide our final decision. The rule of law ensures that judicial decisions are based upon our Constitution and our law, not individual views, outside influences, or opinions of the day. We, the judicial branch, can only perform our constitutional mission when our courts impartially apply the United States and the Iowa Constitution and the laws of the land. In closing, it's important to remember that our Constitution belongs to all of us, all Iowans. We must take great care to protect this document, but we must also strive to do better to understand and appreciate its importance in our lives and our future.
Hello. Today, I will discuss briefly how the Iowa Supreme Court works and the process of oral arguments. Most of you have probably seen a trial, either in real life or portrayed in a movie or TV show. What happens after a trial ends? When a party is unhappy with the result at trial, the party may appeal the case to a higher court called an appellate court. An appeal is a higher court's review of a lower court decision or judgment to assure that a proper decision has been rendered. The right of appeal is a fundamental element of procedural fairness as generally understood in this country. Iowa has two appellate courts, the Iowa Supreme Court and the Iowa Court of Appeals. The Supreme Court is the highest court in the state, and its decisions are binding on all other Iowa state courts. All appeals first come to the Iowa Supreme Court, and it decides which cases it will hear and which cases it will send to the Court of Appeals. Typically, the Supreme Court will hear cases of particular significance to Iowans, or cases of first impression, which means cases presenting important new or novel legal issues to be resolved. After an opinion is filed by the Court of Appeals, the parties may seek further review by the Supreme Court. This procedure is commenced by filing an application for further review. The Supreme Court as a whole decides whether to grant or deny the application. What happens on appeal? The appeal process is very different from a trial. There is no testimony from witnesses and no jury. Parties are not allowed to introduce new evidence on appeal. The appellate court's job is to review the lower court's decision for significant legal errors and resolve disputed questions of law. For this reason, the appellate court considers what is called the trial court record, which includes the evidence admitted during the trial, transcripts of witness testimony, and rulings from the trial court. There is another difference between an appeal and a trial. In the trial court, one judge presides over the case and makes decisions. In the Supreme Court, the 7 justices are collectively responsible for making a decision. Why do appellate courts have group decisions? The basic concept of an appeal is that difficult legal questions are decided by a group of justices, rather than merely substituting the opinion of one appellate judge for that of one trial court judge. Oral argument is an opportunity for the lawyers to emphasize certain legal principles and for the Supreme Court to ask the lawyers questions about the case to help clarify the parties' legal arguments. The justices may and often do interrupt a lawyer's argument to ask questions. Time is limited, and the justices may want to focus the argument on particular issues in the case. Oral argument is not an opportunity for the lawyers to bring up new facts or raise new legal arguments that were not brought up at the trial court. Lawyers must limit their presentation to information in the trial court record and to the legal issues raised on appeal. The lawyer representing the appellant, the party who brought the appeal, argues first. The lawyer representing the appellee, who is on the other side of the case, argues second. Finally, the lawyer representing the appellant will have rebuttal time to respond to the appellee's arguments. Oral arguments presented to the Iowa Supreme Court take approximately 35 minutes per case. Sometimes during oral arguments, a justice will consult sources like the Iowa Code. Because the Iowa court system is making the transition from paper to electronic documents, some of the justices store the legal sources in electronic form on an iPad during oral arguments. After oral arguments, the justices meet to discuss the cases and the arguments they heard. Later, one justice, who has the task of writing the collective decision of the court, will write a draft of the court's opinion and circulate it to the other justices. At the same time, the other members of the court are also writing opinions for other cases. Opinion drafts continuously circulate among the members of the court. During this time, the justices comment on the circulating opinion drafts and debate legal points with each other. This process continues until a majority of the justices agree on a final version of an opinion. A justice who disagrees with the majority opinion may write a dissent that explains why the justice disagrees.